Mr. Haynes is here. It's being live streamed. Got it. Okay. Let's see. Who else we got? Mr. Lincoln is here. We got a whole bunch of other people. So, all right, let's get this shindig rolling here. Where are we? Well, first and foremost, welcome to the October 19th edition of the Rockland Zoning Board of Appeals. Let's see. All members are here, and they are everybody's remote. Mr. Tanzi's remote, myself, Mr. Baker Sr., Mr. Baker Jr., Mr. Galley, and Mr. Haynes. Let's read the legal notice. Notice hereby given that a virtual remote continuance public hearing will be held at 6:30 p.m. on October 19th, 2021 on the petition filed under Chapter 40B comprehensive permit by Shingle Mill LLC, care of Conoco, 41st Street, Bridgewater, Mass. 02324, to allow the construction of 236 units of residential housing, the project, within two 5-story buildings on approximately 29.33 acres of land located at 0 Pond Street and 152 Wilson Street, the site. The applicant is proposing 25% of the units to be classified as affordable as per Mass General Law, Chapter 40B. The site is located on 0 Pond Street, Lot 13, Map 9, and 152 Wilson Street, Lot 68, Map 10. A copy of this application is available upon request electronically from the town clerk by dialing 781-871-1874. Press 1 for the town hall, and then extension 6 for the, okay, I'm done. All right, welcome everyone. Mr. Lincoln, where'd you go?
I'm right here.
You're right there. Got a letter from you. Do you want to talk about the letter?
Sure. Which letter?
Rob,
Who's
do
calling?
we have to vote to open the meeting?
It's a continuance, so it's already open.
Okay.
Technically,
I thought every meeting we had because we're remote, we had a vote.
Okay.
Meeting.
I'll take a motion to open the public meeting.
Motion.
I got a motion. Who was my second?
Second.
I got a second. Roll call. Mr. Tanzi.
Yes.
Myself is a yes. We got full board today. So Mr. Baker Sr.,
Yes.
Baker Jr.,
Yes.
Mr. Haynes.
Yes.
Meeting is open. Mr. Lincoln, let's see. There was an email sent to Candy Dorenzo.
Okay.
Talking about, let's see. Can you let Rob know that I have changed the players? Jones Street is out. My attorneys Don Nagel and Walter Maroney are communicating with Bob Galvin to arrange an internal meeting with everyone. Reason You want to talk about that?
Sure. So you stole my thunder a little bit, but that's okay.
Well, that's why I went to you first.
By mutual agreement, and I've had kind of an increasing desire to kind of get back in. So Jones Street's out. Dave Andronico is out.
Okay.
By mutual agreement, no hard feelings or anything, but I felt simply that I probably would have done several things differently, but that's it. It ran its course, and now I'm in, and we're hoping to do a few things differently. I've got some different ideas. In a couple of minutes here, Walter, you all know, is been my attorney on several projects and great permitting guy. Don Nagel is new to the team. He's an environmental attorney. I'll let him introduce himself. Former DEP counsel for a long time, I believe, out of Situate. So that being said, we don't have a tremendous amount to talk about tonight because I have to get in with, I'm going to keep the engineers, obviously. I thought Ty and Bond did a great job, and the site's, let's say it's 95%. I like the way the site laid out. My beef was more with the architecture, the reluctance with the flat roof, the sidewalk up to the road, digging in their heels on a unit reduction, so I'll kind of leave it at that for now. But I think a lot of my attitude will be different. So that's why we've reached out to Bob to try and maybe chat a bit internally. I'm certainly willing to do it in public hearing as well, although that's where everything gets vetted out eventually anyways. But to try and kickstart the thing. So let me, Walter, let me introduce Don, and maybe Don can chat for a little bit and open for questions at this point. We've had a couple of conversations with Ty and Bond already, but in my opinion, I kind of wanted the internal meeting first, if possible, and kind of talk on a macro level about, for instance, reducing some of the units, which reduces some of the parking and cleans things up a little bit. And then architecture, I think, is a big one. So, without further ado, Don, do you mind introducing yourself? Don, you're on mute.
There we go. Sorry about that. Hi, everybody. My name is Donald Nagel, and I've been brought into this, so I'm getting up to speed, but I think I have a good handle on, the moving parts here. And in that context, I did reach out to Bob Galvin to, try to get some, at least some informal conversation going about some of the things that Rick talked about. So, I look forward to that so that we can just be efficient when we do appear before the ZBA and to, whittle down the issues as efficiently as possible. So that's why I'm here. I do, to the extent that the letter from H2 Olson is something that this board wants to address tonight, I'd be happy to address it on behalf of Shingle Mill. But if that's not something the board wants to get into tonight, that's fine. But I'm just here and prepared to talk about that if that's something the board wants to hear from.
Hey, Rob, it's Bob.
Sir.
Maybe I could ask a couple of questions that would help the board. And these are questions I think that Rick and Don could probably answer. So, and it is true, Don, and I've known Don for a long time. Obviously, I've met Walter through this process, and I know of his firm, and I know Rick Lincoln as well. When I talked to Don last week, I said, look, we haven't heard from, the project team in a while, and we knew that there were matters ongoing with the Conservation Commission, and they appeared, at least because we didn't hear much, to be significant. And I think that was kind of the impression we all had. And I think it might be helpful if you all, even if it's on a macro level, kind of tell us what you're thinking about the project and maybe give us a preview of where you think we're headed from a regulatory perspective on the conservation related issues. The project that the board last saw was a large 5-story project, situated in the middle of the site. The architecture was fairly plain. The applicant was not really desirous of doing any type of offsite mitigation with sidewalks, although appeared to be willing to connect something down Pond Street towards the nearest residential subdivision. We mentioned connections up to Home Depot or through Home Depot, but that didn't seem to get a lot of traction. And, you know, we knew when we last had a meeting that there was a fairly significant conservation issue, and it has, and we know that it has to do something with the Zone A, and we know it has something to do with the water supply and potentially some conservation related jurisdictional issues that couldn't be determined because of the elevated groundwater in the spring. So anything you can tell the board, I think, would be helpful. And I think anything you tell the board in front of the public will be even more helpful to them, because they probably have 1,000 more questions than the board does. So maybe that's a segue to you, to invite you to share with us what you can, and, you know, give us a realistic time frame for new plans and things like that, so that people's expectations are straightforward. I think that's probably the best thing to do. I mean, I assume if there's a material change in the plans, we may need to send it back out for peer review and things like that. So does that help? Maybe introduce it?
Yeah, hey, Don, do you mind if I just kick it off quick? Because
Sure.
if you talk first, I'm gonna forget that, you know.
Yeah, go for it, Rick.
You know, because mine will be short. So water, as you all know, and the public knows, you know, I've drilled the 3 wells out there, and they're down about 800 feet. We've tested them for PFOS and all that stuff. They're clean. So we are coming up on a what they call a pump test, where all these professionals get out in the field together, and they put these instruments in the wetlands, and you run a pump test to make sure that you don't draw down or impact anything on the surface, you know, specifically wetlands. We don't think there'll be any impact, but that's just a guess. That should be done within the next 30 days. The intent there is to produce our own domestic water. We've already there's plenty of water down there, so the volume is fine. The next and final step, well, I shouldn't say final, because then we put nuts and bolts to it with a system. But so that's happening in the next 30 days. I will say, on a macro level with the civil engineering, I like the way the site lays out. So I think it's probably how do I say this cleanly, but it's just a little bit too much for the site, you know, kind of the wall-to-wall approach. Not talking about a drastic reduction in units, but, you know, definitely up for chatting about some reduction in units, which again allows us to pull back some of the parking, reduces the trips per day, which gets us under a particular threshold, and stormwater then works. So I don't think engineering is problematic at all. I think it's more architecture, and then Conservation Commission, which Don knows a lot more than I do. So, Don?
Yeah, so I think it might be helpful for the board to hear on really 2 issues that really seems to be pretty prominent with the Conservation Commission. And one is the waiver, our application before the ZBA seeks a waiver of the wetlands bylaw. The Concom is saying that until that waiver is actually issued, they're going to review it under the bylaw as well as the State Wetlands Protection Act. So it's a little bit of the chicken and the egg. And I think there's a way to get around. I think there's a way to deal with it, but that's kind of banning back and forth between the applicant and the Concom and the peer reviewers are saying, look, you got to meet these requirements under the bylaw. And we're saying, well, we're seeking a waiver under 40B of the wetlands bylaw. So I think that's just going to work itself out. If I could just leave it at that, unless anybody has any questions about it.
I can make a comment about it. We saw some communication that came from your team that went to the Conservation Commission. And it led the Conservation Commission to believe that you thought that the zoning board was going to absolutely 100% grant that waiver. We've never said that. We barely even scratched the surface on that. And this is why I get communications from the Conservation Commission asking, why would we even consider granting a waiver from the wetlands from the wetlands bylaw? We haven't even gotten to that point yet. Everything kind of fell apart at that point. So, you know, to kind of just like gloss over the idea of, you know, the wetlands bylaw and you asking for a waiver from it and thinking that we're going to grant one, we haven't even gotten to that point yet. So that needs to be understood by everybody, that nobody on this board has made any determination or any decision whatsoever when it comes to our wetlands bylaw. And to see that communication from your team to the Conservation Commission saying that you felt that the zoning board was going to waive that was, while it's your opinion, and I appreciate that, I can't say that that's going to happen. So that's something that's going to have to be, that is definitely something that's going to have to be addressed when it comes to that, you know, when it comes to our town's wetland bylaw. So that's really all I wanted to say on that.
If I can.
Yeah, I
follow
mean, I'm
up.
not presupposing any decision the ZBA may or may not make.
Mhm.
But we have applied for a waiver,
Mhm.
and that's pending. And in the meantime, you know, we're getting comments back from the peer reviewers addressing the bylaw that we expect that will be waived. And we know that the board hasn't considered it yet, but it will consider it at some point. And we do expect the waiver to be approved. We expect that. Now, that doesn't mean that the board will, but that's what we expect, and that's how we communicated it. So in terms of dealing with the Concom, we're working really under the Wetlands Protection Act, not under the bylaw.
Mhm.
And so there's a little bit of,
Mr.
so
Chairman,
there's a little bit of a chicken and egg, as I said at the outset, but I expect as time goes on, we're going to get that issue resolved. Okay.
Thank you.
Mr. Chairman,
Yes, sir.
yeah, if I could just follow up on your comments and Mr. Nagel's sort of response. You know, you're entirely within your rights to project to this board, to the Conservation Commission, or whoever else you might feel appropriate what your hope is as far as any action this board might or might not take regarding the wetlands. But to insert this board into that projection, I think is, at the very least, inappropriate. Thank you.
Okay, the other is,
Dawn,
Listen.
could you maybe, you and I had a conversation and we talked about the Zone A thing, and I think just previewing that issue might be helpful, because honestly, at the last public hearing where this matter was continued, we knew that there were wetlands that couldn't be delineated because of the height of the groundwater. There was flooding or spring flooding, and that was a major reason why the hearing process stopped. So perhaps even a preview of some of the preliminary things you've determined and would be helpful to the board to hear.
sure, yeah. Yeah, we looked at the Zone A issue is a big issue that's been run through the Concom, and you know, we have an expert that we got on board to look at that issue.
Dawn, when the board probably is not an expert, we've not had a 40B with any type of a Zone A issue, so
Yeah.
maybe even just giving them a,
Define
I
what
know
it
you
is.
know it, some
Sure.
really basic concepts of what that means and
Yeah.
what it means in relation to the project would be helpful.
Right. The concept of Zone A is under the Mass DEP wetlands water supply regulations, in which it identifies an area where there is tributaries that contribute to a surface water supply. And the tributaries, there's definitions that define what a tributary is and what it isn't. And there's a 200-foot area from the bank of any such tributary that is considered, that is protected under DEP's water supply regulations, such that 200 feet from the bank of a tributary is protected in a number of different ways. So we've been in discussions with DEP and with the Conservation Commission and going back and forth as to where there is or is not zone A's or a zone A within the project area. And I did submit a letter to the Conservation Commission addressing that issue recently, in which I indicated at the outset, you know, the issue of a zone A is the whole concept is of a zone A is a matter of Mass DEP jurisdiction. It's not a wetland resource area. It's a water supply protection zone administered and enforced by Mass DEP, not the Rockland Conservation Commission. So the Conservation Commission really doesn't have any jurisdiction over zone A's. It's a matter of DEP's water supply regulations. So to the extent that there's any disagreement about where there is a zone A and what areas of the project site is or is not protected as a zone A, is really an issue with Mass DEP, not with the Conservation Commission. And zone A's are determined under Mass DEP regulations, not under the Wetlands Protection Act, not under the local bylaw. So as I said, we have, since this is a difficult issue with the Conservation Commission, we hired an expert to go out there and check it out and come up with an opinion. Our expert, John Field, determined that there isn't any zone A located within 200 feet of the property of the project site. And so, we've submitted those comments and that report to the Conservation Commission. And it's under review there, and we'll be addressing it with the Conservation Commission at the next scheduled hearing.
But what you're saying is that the conservation, it's not in their jurisdiction.
Correct. I mean, there's wetland resource areas that certainly are within their jurisdiction.
Mhm.
And if there's a wetland resource area within a zone A, then certainly the Concom has jurisdiction to deal with the zone A, but only as it relates to the wetland resource area,
Mhm.
not as it relates to the zone A per se. And to the extent that there's any, discussion about or controversy about the location of the zone A and the implications of that, that really is something to be taken up with the DEP, with the Mass DEP, not with the Conservation Commission.
I'm sorry, I didn't mean to interrupt. I didn't mean to interrupt. But that you're saying is when it comes to the location of this zone A, this is in Mass DEP's hands. Mass DEP makes the determination as to where that is, correct?
That's exactly right.
All right. And if for some reason they decide to change that location and make it less invasive to the project, it's in DEP's hands.
That's correct.
Okay. But from a regulatory standpoint, how can this zoning board, if it's no longer in the Conservation Commission, and if it has nothing to do with the Wetlands Protection Act, how can this board even look at this project seriously, knowing that you can't build it within state standards at this point? Until DEP changes that, now it falls back into our lap.
Yeah, I mean, that's a very good point, and I thought about that in terms of timing. And you know, what should or should not be, or but need to be resolved before this board, you know, digs into the substance of the details of this. And, you know, my thought is that, and I haven't really talked to Rick about it that much, but my thought is that we should go through the conservation, get that resolved. To the extent that there's any issues with the location of the zone A, I think those should be resolved before we go back to the ZBA. So that your point is that whatever ambiguity there may be, it'll be resolved by the time we get to the ZBA. So
And that makes sense.
yeah, so there's a timing issue there. And, you know, my thought is let's address the issues and whittle them down in the appropriate jurisdiction in a timely manner and sequencing in a way so that when we get back to the ZBA, there won't be this ambiguity that you have to wrestle with. And so that's kind of my outlook on how to handle the zone A, not with the ZBA, frankly, not with the Conservation Commission, but really with DEP. And, you know, I think there is, frankly, a difference of opinion between what our expert says and what the peer reviewers say with regard to the zone A. And I think that needs to be worked out at the jurisdiction of DEP, not within the here or at the Concom.
No, that's understood, and I appreciate that, because again, the Concom has no jurisdiction over the location of the zone A. The ZBA has no jurisdiction over
Right.
where the zone A is.
Right.
It's again, from a regulatory, the state says you can't do some specific things. Can you touch on that? Can you touch on what you can and can't do within the zone A, or is that not kind of in your purview?
Yeah, I could touch on it briefly. The, zone A, it, restricts impervious surfaces, piping, sewer pipes, things like that. So it's a pretty significant restrictive jurisdiction.
What I read said that even wells within the zone A were restricted, but yet you've got 3 wells in there. So it's like,
So that's why this is such an important issue, Chairman, that we want to get this resolved at the proper level and not, frankly, waste this board's time about arguing with it when neither the applicant nor the board really has the authority to resolve the issue. And so as the applicant, we need to just follow the trail where it takes us with regard to any dispute. If there is really a dispute, I suspect that there is, based on the current positions of the parties, but that needs to be resolved with DEP. We want to resolve that first and then come back to the board.
what's the next step when it comes to this? Because again, I've gone through a lot of the communication, different people saying different things. What's the next step? It seems like everybody's getting lost in this because they can't seem to find it. They're saying they can't find it, or it's too difficult to find, or something like that. Yet there was one piece of communication that said that they found the entry to all 3 tributaries. So it's a matter of how far do these tributaries extend into this, into the property. I'm just.
Yeah, the key, a lot of this is driven by definitions. And I'll just throw out two key issues or two definitional standards. One, for it to be a zone A, it has to be a tributary to a surface water supply, of course.
Mhm.
And that tributary has to have a definite channel with banks on either side. And that those banks have to contain, it could be perennial or intermittent, but there has to be water flowing through it at a gradient. In other words, it can't be just sitting there. It has to be flowing at a gradient.
Mhm.
And there has to be definite banks to the channel. And so we looked at that very carefully. DEP, they have Mass GIS where they map a lot of this stuff.
Mhm.
And DEP is relying on that, but like wetlands, delineations on Mass GIS, they're there. Really, they're not supposed to be used for delineation purposes,
Mhm.
but they're there for reference. They're there as a starting point, not an ending point.
Mhm.
And so, what's on Mass GIS really is subject to verification. And I know there's been a couple of site visits, and I've been there myself, and it's tough. It's a tough site to get into. So there's those are the things that we're looking at. And I think those are the things that, in terms of whether there's a definite channel, whether there's a gradient with water flowing through it intermittently or otherwise. Those are things that we need to resolve with DEP. And we don't want to waste this board's time, or frankly, the Concom's time, with grappling with this when really the procedure, and really getting to your question about how do we sequence this thing. I think we need to get back to the Concom and clarify that this is really an issue we need to address with DEP. So what does that mean with regard to how the Concom will proceed under those circumstances? And the same question arises with regard to the waiver issue, the bylaw waiver. So those are two issues I think we need to work out with the Concom, such that my hope is the Concom issues their decision, and it may be the decision is issued only under the act, and that risk could be on us, frankly, if the order is issued only under the act and not under the bylaw. And we may, I know there's a little bit of bristling at the idea that we expect the ZBA to approve the waivers, but that risk is on us if they don't. And if they don't, then we're going to have to go back to the Concom and apply under the bylaw. But my thought is that if we narrow the issues with the Concom such that they recognize that the Zone A is not on their turf, it's with DEP, and if the order is issued under the State Wetlands Act only, then we're clear. Then that helps us get back to the ZBA, and it also clarifies. It puts us in a position where we can deal directly with Mass DEP on resolving this Zone A issue, which obviously influences how this project is designed.
Mr. Chairman, through you to Mr. Nagel, if I may. Just throwing a hypothetical out at you, what would it do to, one, the timing of your process, as well as your intentions for the process, were the Conservation Commission to dispute your jurisdictional interpretation?
And they're free to do that, absolutely. And their decision would reflect that.
Right, and I'm saying, what happens then?
Well, there's an appeal process for order conditions to the DEP. So that may or may not be how this thing plays out, but that's a good question. you're asking a good question, and it may very well happen that the Concom disagrees with us. I think that they don't have a legal foundation to do that on this Zone A issue, but let's say they disagree with us and they deny it based on the project has features within the Zone A that are they don't think are approvable. They deny the project. We appeal to DEP. We address the issues under the Wetlands Protection Act, and I would imagine we would also address the Zone A issue with DEP, not specifically under the appeal, but it is part and parcel to the project. So if we have a request for a superseding order with DEP, and we also have an issue to resolve with the Zone A on the same project, then it kind of makes sense that the proper venue would be DEP at that point.
Okay, so if, as you suggest, resolution with the Conservation Commission is the first step in what may be a series of subsequent steps, and there is this hypothetical disagreement, that's going to set the timing of this whole project back, well, knowing or having some idea how government agencies operate, perhaps significant.
It may.
Okay, thank you.
Yeah.
Anything else, Mr. Nagel?
No, thank you.
All righty. Mr. Lincoln, what I wouldn't, again, you're affiliated with Conoco, correct?
Yeah, I own Conoco.
Okay, so you have your engineers under your belt. I don't see any of the engineers here today, correct?
Correct, although Conoco is the wetlands component, Ty and Bond is the civil component.
Civil, okay. Whoever is looking at the wetlands, the wetland impact, the buffer impact with all the construction that you're trying to do. I know we've gone over this before. What I'd like you to do is talk to whichever company is dealing with this. Look at the wetlands bylaw that Rockland has, and I need a worst case. All right, I need a worst case because I've been in communication with the Conservation Commission, and what they have told me is that in a situation like this, when it comes to resource area, when it comes to buffer zones, they would require some sort of mitigation, some sort of wetlands planting, like a 2-to-1 wetlands planting or something like that. I've dealt with other towns in this situation when it comes to basically wetlands and buffer mitigation. I'd suggest you guys go put that together, and a worst case scenario, if there is replication area that you would have to put together, at least put it on paper to see what in your situation, what the worst case is. Because we haven't even really touched on this. We know you're getting close. We know you're getting right up to it, which means that 25-foot buffer in most cases, most specifically with the entry road, is gone. So if there is some sort of replication areas that need to be put together under the wetland, under our wetlands bylaw, I think we all need to be prepared for that. I know we've seen plans that have impacts to this area, impacts, what percentage of pavement in this area. Well, I need you to look at it from the wetlands bylaw situation. What you guys would have to do if you were to follow the wetlands bylaw 100% to the letter of the bylaw. And then then give us some way to look at it and say, okay, well, this isn't too bad. We have to do this. Just like if somebody was asking for a variance, we need to know how much of a variance you need. So in this case, we need to know how much you would literally have to either replicate or something like that to be able to say what we can, what we can waive and what we can't waive. You hear what I'm saying?
I do. Trying to figure out how to respond to that. So first of all, there's no direct impact, it's all buffer zone at this point, and that's going to change depending on, State Wetlands Act versus local bylaw. That's one thing, but I would defer a little bit because I still feel that we'll be able to peel back the pavement a little bit. And some of that depends on our discussions regarding a bit of a unit reduction. So if we can kind of come to an agreement, nobody will be completely happy, right? But if the units do reduce at whatever level, that's going to reduce the parking requirement, and it's going to allow me to pull stuff in.
Right.
Away
Let's
out
talk
of
about it.
buffer zone.
So let's talk about it. How many units you taking away?
We
throw it
have
out.
no idea yet.
Right. See, this is the problem. There's a lot of, oh, we're going to change this. We're going to change that. We're going to change this. That's great. That's great. We like it. That's the word, and change is good. The problem is that depending on how much you change it, this may not even be anywhere close to the first submittal that we saw. So it's like, it's almost a new submission. And I'm just, that's what I'm nervous about. If you're only talking about taking away 5 units, okay, that's not necessarily a big change. But if you are talking about losing a floor, well, that's a lot of units, and that's a lot of paving, and it's a lot of change, and it's a lot of drainage change, and there's a lot that goes on there. And I'm sure you've already thought about this. So it's like, how big of a change are we talking here?
Could I make it?
I would say
Sure.
just somewhere in between. I don't mean to be evasive, but I am willing to, dig in and come up with something that's really going to work. My only reluctance right now is obviously we need to get through the Zone A and try and get through Concom and DEP, because the rest could be an exercise in futility, right? I mean, we could be just doing it for exercise. That's it. It doesn't mean anything. So I'm not being evasive. I just don't want to commit to anything until we figure out how we're going to work through Concom and Zone A, whether that works out.
No, that's absolutely understood. Attorney Galvin, do you have anything to say at this point?
Yeah, I mean, one of the things that I've been just kind of hearing anecdotally, and I don't know this to be factually true, so take it for what it's worth, but there appeared to be some concern that this property or a portion of this property was Zone A to the Hingham Reservoir, and that tributaries from this site lead to that reservoir. And I don't know whether that's true or not true. So don't assume it's true. That's the rumor that I was hearing, and if that's the case, is this site or the tributaries in this site within that, in the state drinking water regulations, within that zone distance where anything you're proposing, is impacted?
Yeah, if I could address that, at least try to. The project is, first of all, the project is fully within buffer zone. There's no permanent wetlands alterations. And those wetlands, I don't think there's any dispute that those wetlands are hydraulically connected to to the reservoir.
Okay,
There's no, I don't think there's any dispute about that. The dispute is where the zone A or zone A's are. And how that affects the Concom's decision-making. So, back to the mitigation question from the chair, I'm not sure it's really a useful exercise to consider the worst-case scenario where the entire bylaw is imposed on this. But the impacts to wetlands are, any impacts that will occur are only temporary. And so, we're out of the wetlands. The wetlands are hydraulically connected to the reservoir, and the zone A is going to be addressed with DEP, not with this board or the Concom.
I can appreciate that. I just, again, we never really even touched on our local bylaw when it comes to wetlands. And again, I can go through my email and I can show, I can read to you who's basically saying, when did you guys say that you were going to waive that? And we never said that we were going to waive anything at this point. We can't say, well, we don't make the decision right now. So
we've only requested it. That's, we're making no presumptions beyond that.
okay.
But in terms of, trying to be productive and moving forward in a productive way without spinning our wheels, I was going to suggest earlier that, in terms of the things that Rick may consider, I did reach out to Bob Galvin previously, and, what I would hope to do is try to, put together an informal kind of working group to just hash this stuff out. And, what ifs, run through some what ifs and try to get a better handle on what is, a project that this board would be willing to approve. And so I think, we're kind of have a bit of a reset here.
Mhm.
And so I think part of it is, instead of coming before the full board and saying, well, we may consider this or we may consider that, I would suggest it may be useful to have, kind of get a working, informal group together that, obviously we, without triggering open meeting law, just get together and have a chat and see what seems to, be reasonable, or what might be something that we can all go forward with together in a cooperative manner.
so the one thing that we do have a practice of doing is the department heads that are responsible for the various departments of the town are probably willing to talk technical details of a project with your project team, but obviously all of the substantive details and decision-making have to come back to the board, and the board has to make the ultimate decision and debate it in a public meeting. So I think that it's possible, and I know we do it on a variety of projects. Department heads will get together and say, okay, this is the process. These are what we're looking for. These are the rules. If there's a question of interpretation on something, they try to answer that, so that the technical aspects of a project can be, you can resolve a dispute. Okay. So I know that we'll do that. I thought it was best, Dawn, that the board here meet you guys first before we schedule that. And I wouldn't have been able to do it from a scheduling thing anyways. And the public ought to know that no decisions are made in that type of a working session, other than like technical details. And if technical details are recommended by experts, then they have to go back to the board for ultimate approval and discussion and debate before there's any vote on it anyway. So that would be the only type of meeting that would happen, if at all. So.
Yeah, just to make clear,
Understood.
Bob, no members of the ZBA would be participants in that meeting, correct?
If anybody attends, it'll be one, but we're not even sure that would have one. Okay.
Thank you.
I mean, in 40B process, you know, it's actually recommended that there be working groups as a project gets down towards the end of its review. But it sounds to me like the board should expect that we're going to get some materially different plans, although, you know, the nature of how they're going to be different isn't actually determined yet. So that's, I think, what they're telling us.
Thank you.
So I think the thing would be helpful for the board to do now is just to ask the applicant, you know, when they think they'd be ready for their next public hearing, and to make sure that we have written extensions in place that give them the time that they want. I mean, you know, this board has talked about actually terminating the public hearing process and, you know, and denying it. And, you know, you can do that, but the reality is they can refile or it'll get remanded and they'll be back here again. So it's not a practical solution to the issue. The more practical solution is, let's see what let them tell us when they're ready to submit. We'll send them out for peer review again at their expense. We will allow them to come in and explain to us what's different about the plans, and then we'll hear from Mr. Brennan and our traffic people. And, you know, if it's a reduction in density, maybe we'll have some traffic benefits to it. If they've solved their conservation issues by the time they come back, then they've solved them, and that's great. And, you know, then we'll be in a position to just, you know, hear from the neighbors and see if there's anything that the neighbors feel is not adequately addressed or properly addressed. Remember, we also have financial review, and whatever takes place here might alter that analysis. So we may have to do that again. So I think what makes most sense is to ask the applicant when they think they'll be ready, because it doesn't make sense to start without that again.
And just to clarify, Bob, by being ready, do you mean when the Conservation Commission / DEP issues are resolved?
I don't think necessarily. I mean, I think you're hearing an argument from Attorney Nagel that some of the things that we all have been hearing may not be exactly contextually accurate. And he may think that there are no issues, and you know, Attorney Mirioni and Nagel may want to make the pitch that this board waived the local bylaw. And, you know, that is your decision, not the commission's decision. That's your decision. So I think that what we ought to do is do what I've suggested and ask them when they're going to be ready to submit. And we're going to put them right online, which we try to do with everything else. And if anybody wants something, people are free to ask. And, you know, a couple of abutters and a couple of other residents have asked for information. We try to send it out as soon as they ask for it, because all of this stuff is public and there's nothing going on behind the scenes that no one has should be afraid of. We want to know as much as the public does about this project.
Mr. Lincoln, can I ask you a question?
Absolutely.
If you guys, if your team is going to be changing paving locations, units, the whole 9 yards, you know, anything that you're going to be changing, are you going to be getting that to the Conservation Commission so they can view that? Or are you going to be asking for basically their decision based on the original project that's still kind of on the plate right now?
Good question. The only thing that might affect, so let me back up 1 or 2 steps. So the changes, in my opinion, and I'm not the engineer and I'm not the wetlands guy, will be just the parking. So, without having a plan in front of me, I don't think the buildings are going to move. I don't think the traffic patterns are going to change. Because all that was worked out with fire department and everyone else, just like the whole Pond Street improvement, all that stuff. So I'm hoping that the change will be architectural units, pulling back the pavement, to reduce the parking. And the impact of those changes would mostly be stormwater. You're just going to have less impervious, so it's going to allow us to maybe move a pond or two. Because Henry Nover had a couple of comments. I think stormwater was really worked out, but he did bring up a couple of comments that we need to address. So if I make these changes, we'll satisfy those comments, in my opinion. I can't speak for Henry. So I don't think they're dramatic changes, but the buildings are going to look dramatically different. Because like I said, I've never liked that architecture. So I'm sure there'll be a lot of back and forth on that. I'm just going to throw out 60 days to try and keep my feet to the fire. 30 days is, way too fast. But 60 days, we should be able to show everybody something, and also give us some time to have a meeting, potentially even two, with Concom.
Okay, so what are we looking at?
Kim is on the line, so she could give you your December meeting dates.
Yeah, what,
December 7th and December 21st.
how you doing, Miss Frizio?
Hi, how are you?
I'm doing good. All right, so 21st. Is that what we're looking at?
60 days.
What a wonderful Christmas present.
I
Thank
was
you.
going to say, I don't know if the Christmas mood will help me or hurt me. So.
It won't be Halloween anymore, but I'll definitely be wearing my Grinch mask. So, let's talk. Board members, is everybody going to be around in December? I know we don't usually do December meetings. So, is everybody going to be around?
What about early January, Rob?
If you want to push it that far, let's see. So we do that. Kim, where are we on the 4th of the 18th?
They're open because we haven't even touched that far yet, so we could do either of those. Up to you.
At this point, Mr. Lincoln, this is your decision. You're requesting that. Board members, how's everybody's schedule at this point?
Fine, any of those dates.
Okay,
I'm fine.
everybody's good? There are no objections. So, Mr. Lincoln, if you want to take it to January, that'll give you 3 months to kind of put this together.
That's a lot of time. Yep.
If that's time that works for you, I mean, that would end up being the 18th, January 18th. Does that work with everybody? That's 90 days. Does that work for everybody?
19.
I'm looking at Tuesday, the 18th of January.
So could I ask just a on the side question, but will the emergency open meeting law doing this on Zoom still apply? Are we going through January? I can't remember the date.
Yes, it'll still be on Zoom then.
All right, so we can still utilize Zoom at that point.
It's more of an availability question. So yes, so that any of those dates would be fine.
All right, perfect. I like that. So Zoom will work. 18th, every board members, everybody good with the 18th? Yes?
Yes.
Yes. Everybody's good. Mr. Lincoln, 18th work for you?
Works for me.
All right, here's the thing.
Rob, we're going to need an extension letter for the public hearing process, which, technically is a 180-day process. I think they've given us an extension letter. I just forgot what the date was, but
October 31st.
October 31st. So we're going to need that public hearing extension process probably into February, because if they're coming in for the first time telling us these changes and it has to be reviewed, I'm going to anticipate we're going to need at least one more meeting in
Oh, yeah.
February or two, so maybe the end of February for the public hearing process.
Walter, can you draft that?
Yeah, I'll have a letter to you tomorrow, Bob, Mr. Chairman. I'll have it to you first thing in the morning.
Yeah, I'd say just do it through the end of February 2022, and then we'll address it in January to see where we're at.
Fair enough.
And Mr. Lincoln, if you can get us these plans by the 4th, by January 4th, that'll give everybody kind of 2 weeks. That way we can forward it to Pat Brennan, we can forward it to fire and everybody, we can forward it to everybody so they can see what's going on. Is that possible?
That's the target.
Okay, so the target is to get everything into the town by the 4th, January 4th, 2022. Next meeting for Shingle Mill would be the January 18th, 2022. I need all that in a motion. Who's going to give me a motion?
I'll make a motion to continue Shingle Mills till January 18th, 2022 at 6:30 on Zoom. The plans submission should be to the town and the zoning board by January 4th.
February 4th.
Chairman,
Attention.
January 4th.
Mr. Chairman.
February.
January.
What are we talking, February
All right,
4th?
February 4th.
February 4th.
What? No,
No, that's after our meeting.
January,
I said January 4th.
right, but somebody's saying February for some reason. Now everybody's quiet. So again, we're gonna say this one more time. When's the meeting, Bob?
January 18th,
January 18th,
January 18th. At what time?
7:30.
6:30.
6:30. All right, at 6:30.
30
Plan,
on Zoom.
and this is January 18th, 2022.
Yes,
When do the plans have to be submitted?
4th.
January 4th of
January
2022.
2022.
Yes,
I've got a motion. Can I have a
that
second?
is a motion.
I've got a motion. Can I have a second?
Second that.
I got a second.
Roll call vote.
Mr. Tanzi?
Yeah, that's fine. I did have a couple of questions that I didn't get a chance to voice.
I'm taking the motion off the table then. Mr. Tanzi, talk.
Very quickly. You brought up a very good point. Who approves the jurisdiction with respect to surface water supply? I'm going to read out of the DEP Stormwater Handbook, which was incorporated into 310 CMR 10, which is the Wetlands Protection Act. That puts this clause in the jurisdiction of Concom and the local boards. And it states stormwater discharges to a Zone 1 or Zone A are prohibited unless essential to the operation of a public water supply. Now, this is in the middle of the page of Volume 1, Chapter 1, Page 2 of the DEP, the Massachusetts Stormwater Handbook. And this is part of the Wetlands Protection Act, 310 CMR 10. So right there, that gives us jurisdiction over discharges to a surface water supply. Now, I want to also state, I've got a concern. Again, I'm going to read it. Stormwater discharges to a Zone 1 or a Zone A are prohibited unless essential to a public water supply. 3 wells have been drilled, all right? A Zone 1 is a protective radius to a well. Now, if a well services more than 25 people by the Board of Health standards,
Yep.
it's a public well. And public wells will have a zone 1 tributary to it. It most likely will not be your typical 400-foot radius that you find with a municipal well having more than a 100,000 GPD yield. But whatever the GPD yield of the well or wells are, there is an equation that the applicant's engineer is going to have to go through and form that radius. Now that zone 1 radius is just like the zone A to the reservoir or its tributaries, and it has to be honored. And you can't have discharges to these protective areas. So those are the two things, two concerns that I have. And the other concern that I have, I was reading the, I guess what Ty and Bond called their 21E. It was their site assessment report. And if the applicant's lawyer has not read that, I would strongly suggest that he does read it, because there was a lot of disclaimer verbiage. The engineer, the applicant's engineer, stated in this report that they make no guarantees that their findings would pass a regulatory audit. That was very red flaggish and very concerning to me. There were other disclaimers that were in there. There's reference that Ty and Bond said they weren't allowed to test certain areas of the site, but didn't elaborate as to why they weren't allowed to test certain areas of the site. So from a regulatory standpoint, there was a lot of very discomforting statements being made that I was very uncomfortable when I read all those disclaimers in that report. And none of those disclaimers were revealed or talked about during the public hearing process. All I can remember is Ty and Bond saying, well, we never found anything that was over a detectable limit of contamination. But the site is a junkyard. In my years of experience, I have never seen a junkyard be so clean. I mean, we had on Boxbury Builders, there was a lot of auto fluff, an old junkyard. You may remember, Mr. Chairman, I think you were on the board at the time, but we gave them extra units if he cleaned it up, and he did clean it up, and we gave him extra units, and the town got a site that was cleaned up. There's no remediation or site cleanup work that was proposed to date anyway. Maybe that might change now that Mr. Andronico is out of the picture. I don't know, but the applicant's attorney should read that report and should take it to heart and read it from the standpoint, if he was on a regulatory review committee or an approving board or committee, and address these issues. And because we can go back and forth about the semantics of is it a zone A or is it not a zone A? But I think the real heart of the matter is that this site, at the end of the day, has been a junkyard. And there's a lot of recharge or stormwater runoff being proposed to be infiltrated on site. And from a 21E standpoint, usually the exact opposite is what the intent is to, a lot of times these sites are just paved over so that you don't get recharge into the ground, so that you don't cause contaminants to migrate. So I've got some concerns. And if you read that report, if you read it very carefully, you will understand where my concerns are coming from. So that really should be addressed on the next go around. You've got your zone A issue, and you've got, most likely you're going to have a zone 1 issue as well that you need to address, because, you know, I'll be looking for these things. Those are my 3 concerns. I think those are the 3 biggest hurdles that this project has. And I don't mean to be adversarial. I'm just being protective of Rockland's water supply and of Abington's water supply. And so with that, Mr. Chairman, I don't have any other questions.
Mr. Tanzi, thank you for that. I now fully understand what your issue was the last time that you and I almost came to blows. I fully understand now. Thank you.
No problem.
All right, I'm going to entertain that motion again for a continuance. Who wants to make it?
I'll make that.
All right. What date?
January 18th, 2022
Time?
at 6:30.
And what's the date that we need everything?
All submittal paper, hard copies and electronically shall be submitted by January 4th, 2022.
I've got a motion. I need a second.
I'll second.
Second.
I got a
Okay.
second. Before I do roll call, does anybody need to say anything else? Board members, anybody, attorneys, anybody? Hearing none. Mr. Tanzi?
Yes, are you gonna have a meeting?
Say again? Who there was,
Are you going to have a meeting outside of the purview?
who is speaking here? I got
Mary Parsons,
Mary Parsons. Where is she?
Dana's iPhone.
Mary Parsons. Okay, I got you. All right, what was the question?
I just want to know if you're gonna have, are you gonna have this internal meeting outside of the public's purview?
I don't see why not.
Well, basically, the public should be able to see that there shouldn't be any reason to have it that way.
Attorney Galvin?
It's not a public meeting. It's a meeting of staff at the town and staff working for this developer to resolve technical questions. The results of anything that's discussed or agreed upon would have to come back to the board for approval. It's not a public meeting. This is normal process. It's not a meeting of the zoning board of appeals.
It's a way of getting around the open meeting law is what it is. It's a working, what's called a working meeting, and it's a way of getting around the open meeting law, and you're coming back with decisions already made.
No, that's not true. I mean, all you have to do is look at any of the guidance documents published by the state about working sessions to understand that these happen. And they're blessed. They're not violations of the open meeting law, because a quorum of this board would never attend those meetings to my knowledge. And if they did, we would, and I was present, I'd have them terminate the meeting.
I never said that it was a violation. What I said is it's a way of getting around it. And yes, I've looked at those state documents, and there are other boards and committees that use that technique. And it's just a way of staying out of sight of the public. Are you going to keep meeting minutes? No.
It's not
It's something. It's something that can be in front of the public, because the public's going to live with this project.
Right. The reality is, if the board doesn't want us to do this, we won't do it in all likelihood. if that's what you want to do, fine. I think you're hampering your ability to do what every other board does in every other town. So I can't think of a reason why you would agree to that, but it's your call, not my call.
So basically what it comes down to is we don't have to, because it has nothing to do with open meeting, we don't even have to discuss it at this point. If we wanted to have this
If the
meeting,
board wants town department heads with technical knowledge to help resolve technical difficulties or interpretations, you have these meetings. If you don't want them to do that, you're going to be deprived of the benefit of that. And, and by the way, if the abutters had people with that were similarly qualified that wanted to have a meeting, I think the board should offer that to abutters and their consultants. It's not like intended to put one person over another or one group over another. It would be an opportunity that either side could take. And, it's intended to facilitate the process, not facilitate an approval or denial.
so do we even need to talk about this right now?
Unless you're opposed to it, then, you don't need to even discuss it.
All right, we're not even going to discuss this at this point. Because it has nothing to do with open meeting law. So no, and Mary, I can assure you that no decisions get made at any of the work sessions that I've ever attended. It's literally to clarify things that certain certain professionals are saying. There's a lot of confusion on this, and sometimes it requires these kind of things. So I can assure you that absolutely no decisions get made whatsoever. That's not the case. That is absolutely not the case.
Mr. Chairman, there's a motion on the table.
I've got a motion on the table. I've got seconded. I haven't heard from everyone. Yeah, I have a second. I'm going to roll call. Mr. Tanzi? Mr. Tanzi?
Yes.
Yes. Myself is a yes. Mr. Baker Senior?
Yes.
Mr. Baker Junior?
I'm not a voting member on this matter, Mr. Chairman.
That is correct. Who was Mr. Haynes? You were the last voting member, correct?
Correct.
Okay.
Yes.
So you got a yes. All right, perfect. All right, so that motion carries. Attorney Galvin, I know it's very late in the game, but seeing as though he's attended pretty much every single meeting since, can we pull Mr. Baker Jr. onto the board so it's a 5-member board as opposed to a 4?
If he's missed more than one meeting, the answer is no, he cannot participate.
Okay. All right. No, unfortunately, I know he has missed more than one meeting. I just, because it's going to be it's not a new submission, but it's definitely.
It is a continued public hearing, so the answer is he cannot do that. And I feel badly, and he should still attend and participate, but he can't.
I plan to.
No, I need him here.
Just to clarify, Mr. Chairman, when the references to missed meetings, it's not that I wasn't in attendance since my appointment.
Exactly.
I believe things happened before I was appointed to the board.
Yeah, he wasn't even a board member at that point. So I wish I tried for you, sir. I definitely tried for you.
I appreciate that, sir.
And I'm not trying to keep you out of anything.
No, I
Bob,
understand.
I'm trying to steer you to comply with the law. So.
All right,
Which I strive to do every day.
Everybody, I got motion, I got second, roll called, everybody was in favor, so that takes care of that. And we also talked about that we're going to, again, who's taking care of Mr. Mira? Yes, Attorney Mirioni, you're going to take care of the extension?
Yes, I'm gonna have a letter to you in the morning.
All right, I appreciate that. And that's through the end of February, correct?
Correct.
Perfect. All right, that takes care of that. Is there anything else that we have to talk about tonight? What else do we got here? Where are we? It's not that one. All right. Unfortunately, I don't have the agenda up. What, is
There's
Deb
no
still?
min-
Who's got the agenda up?
No, that's it, Rob. Just non-deliberative.
That's it.
announcements.
Yeah, non-deliberative in minutes, and we had no minutes to approve, and then there was really nothing else there was nothing else that we had to talk about, so. All right, so I need a roll call vote. I need a motion to adjourn.
Make a motion.
I got a motion. I need a second.
Okay.
I got a second. So there was a motion by Mr. Tanzi. I got a second by Mr. Hans to adjourn. Roll call, Mr. Tanzi.
Yes.
Myself, yes. Mr. Baker Senior,
Yes.
Mr. Baker Junior,
Yes.
Mr. Haynes.
Yes.
Get out of here. Thank you everybody for coming. We'll see everybody again on January 18th at 6:30.
And thanks, everyone.
Thank you, everyone.